Nice to meet you. Good afternoon. Today we're pleased to welcome 7 witnesses representing the Federal Trade Commission, the consumers, industry, especially businesses with an internet presence and whose main line of business is to create and sell advertising. And I would like to thank them for taking the time out of their busy schedules to share their perspectives on consumer privacy, as well as to outline their view as appropriate offline and online business privacy protection and personal information use practices. Have you ever been in the midst of a group of people and heard someone say, what's said in this room stays in this room? As someone in that room, you know just from that statement that what may be said could be juicy enough, sensitive enough, or valuable enough to tempt one of the other persons in that room to violate that compact by leaking that information to people who are not in the room during the discussion. And the very utterance of these words evidences a conscious intent by the participants to set the needed environmental conditions that would encourage those in the room to interact freely with one another and to share data, share information, without the fear that that very information will harm them economically, emotionally, or otherwise at some point in the future. As an avid user of the internet and as a person interested in technology and communications and all things digital, I know there is no free lunch where I go onto an internet website to read or view content, especially when I'm not paying for that content. That internet website and the advertisers who underwrite the overhead and operating costs of that website know that my information, whether it can be used to identify who I am or whether it gets merged in with other users' information, has substantial value and can be monetized when it is provided to others. Before the House was scheduled to adjourn for its August recess, I, for one, felt that it was imperative on Monday of this week to introduce privacy legislation in the form of H.R. 5777, the Best Practices Act. I also thought it was important that we quickly hold a hearing in this subcommittee on the assorted pros and cons of my bill, as well as the other issues outlined in the discussion draft released by Chairman Boucher and Ranking Member Stearns of the CIT Subcommittee. The Best Practices Act speaks to a host of issues affecting consumer privacy, including consumers' expectations as to how their personal information should be handled, shared, and disclosed to third parties. This legislation also addresses other important issues, including what defaults should be set in connection with those expectations to provide regulatory certainty to industry and to investors. What safeguards should be crafted to anticipate foreseeable abuses and violations of consumers' privacy expectations? What sets of remedies will make consumers whole in the event of privacy breach? And how to calibrate penalties and other possible legal causes of action without chilling industry incentives to innovate and grow their businesses. This legislation also addresses to what extent, if any, should the privacy framework set forth in my bill preempt state privacy laws and regulations. In holding this hearing, I would like to get a better handle on how extensively personal information gets shared without individuals understanding and without their consent. I also want to shine a spotlight on some of the actual harms that befall individual users through no fault of their own. With that said, I yield back the balance of my time, and now I recognize the ranking member of the subcommittee, Mr. Whitfield, for 5 minutes for the purposes of opening statement.
Well, Chairman Rush, thank you very much, and we certainly appreciate our panel of expert witnesses here today. As you know, we're having this hearing to explore privacy legislation. I want to commend Chairman Rush for introducing his bill, and I want to thank him and his staff for giving us an opportunity to review that legislation. And all of us recognize that some steps need to be taken in this area, and we're hopeful that after today's hearing, a lot of these issues will be clarified even more for us because, as I said in the beginning, we look forward to your testimony on this important issue. It seems to me the threshold question is whether Congress can require meaningful protections without forcing businesses online and offline to abandon or severely curtail legitimate business practices that benefit consumers. We know that it's easy to misuse information, and we also know that there are benefits from sharing information, so that balancing act is very important. The problem, I believe, for most consumers is the lack of understanding about how their information is collected, and once used, how, and once they provide it, how that is being used, and the impact that it has on them. This is a preparatory hearing, and we always have a lot of concerns about legislation, particularly when it's in the area of privacy. One of the areas that I have some concern about is that the first party, third party distinction created by this bill could also give certain players in the Internet ecosystem a competitive advantage over others, and I think we need a level playing field. I think it would be very difficult also for Congress to be involved in every nuance of privacy. And I think we need to be very careful about the latitude that we give the FTC in this area. One of the areas that is vitally important, obviously, in policing any legislation is the enforcement mechanism. I'm always concerned about private rights of action because I know in some instances it has really created a cottage industry for trial lawyers seeking to manufacture privacy concerns. But I also know that sometimes those appear to be, these private rights of action seems to be a good way to go. I do support the ability of state attorney generals to enforce the federal statute. I don't think this bill goes far enough in terms of preempting state laws, creating the possibility that despite the bill's intent, covered entities would be subject to actions under multiple, potentially conflicting laws or legal theories for conduct sanctioned by this bill. Whatever Congress ultimately enacts, consumers will not care really about the corporate structure or the regulatory regime that governs the entity collecting their information. They only want to be sure that their information is treated the same by all entities and that they have reasonable protection. And I feel quite confident that when we enact privacy legislation, that we'll have a balanced bill that everyone will be satisfied with. Maybe I shouldn't say everyone, but most people will be satisfied with. And, of course, that's our objective. And I yield back, I balance my time.
We'll be seeking everyone on this bill. We'll now have Ms. Castor for 2 minutes.
Thank you, Chairman Rush, very much, and thank you to the witnesses for being here today. I'm looking forward to your discussion of consumer privacy in the internet age and in such an exciting age of technological innovation. And I hope your comments will be directed to the two draft discussion bills that are on the table. We need your expert advice on how we balance the important competing interests of personal privacy and business innovation. We do need to have rules in place that give consumers the option to share their information or keep it private. Both bills before us require that companies explain to consumers what information is being collected and gives them the ability to opt out of certain data collection practices. And I think this is what consumers are looking for. They want a simple explanation followed by a choice. But there are literally thousands, millions of new businesses that have been created as a result of the ability to share information. And I think this is absolutely vital that we protect that interest as well. Nearly all internet businesses rely on some form of information gathering. So we want to ensure that these businesses continue to grow and flourish, but in a way that protects, that promotes transparency for the consumer. So thank you for being here, and thank you, Mr. Chairman. I yield back.
Thank you, Mr. Chairman. I want to thank you and Ranking Member Whitfield for having this hearing on the bills before us today, both focusing on consumer privacy. I'm pleased that we're once again examining this issue and that legislation has been brought forward with the goal of protecting consumers and their personal information. I look forward to hearing from our panelists and discussing the merits of these bills. As we take them into consideration and debate the best steps moving forward, I hope we proceed wisely and carefully. As I've stated at previous hearings, I hope we focus on how to protect consumers and their personal information and look at steps the industry will take on their own to do that. We need to make sure that these bills do not focus on ways government can get involved in more areas of people's lives where it does not belong. For this reason, I hope these bills take self-regulation into account and include provisions that allow companies to continue with steps they've already taken to protect personal information. If self-regulation is not sufficient, and if any additional privacy provisions or regulatory requirements are needed, they should be targeted, consistent, and not discriminate against any one business or industry. Congress should not pick winners and losers. I also hope that these bills do not harm the ability of companies to maintain or invest in their businesses. We must strike a balance that protects personal information without limiting a company's ability to do business in an honest and ethical way. Again, I look forward to hearing from our panelists on whether they feel these bills strike that important balance. Mr. Chairman, I also want to close by addressing the rumors that FCC Chairman Janikowski may add broadband classification to the Commission's September 16th agenda. First of all, I do not believe that the FCC should reclassify broadband services or impose burdensome regulations on the Internet. And more importantly, the FCC should definitely not rush any process that gives Congress little time to react after returning from recess. Over 8,000 pages of comments have been submitted to the FCC on this proposal, and the comment period is open until August 12th. For reclassification to be on the September 16th agenda, the other commissioners would have to receive the chairman's proposal by August 26th, giving the commissioners 2 weeks to review the thousands of comments. Clearly, we need to make sure that they have that ability to review those comments from the public. So I hope those rumors are in fact just rumors. Otherwise, it would seem the FCC intends on ignoring those 8,000 pages of comments, as well as the bipartisan staff discussions that are ongoing on this issue. We must continue to pursue targeted legislation that serves the American people, not a hastened process that serves a political agenda. Thank you, and I yield back.
The chair recognizes now the gentleman from Georgia, Mr. Barrow, for 2 minutes. Mr. Green, you're recognized for 2 minutes.
Thank you, Mr. Chairman. Thank you, Chairman Rush and Ranking Member Whitfield, and I want to thank you for raising the issue of consumer privacy and for holding this hearing today. And also Chairman Rush and Boucher, as well as Ranking Member Stearns, for introducing the bills which we examine today. As technology continues to evolve, the privacy implications for consumers require frequent re-examination by Congress. In 2003, we passed the Canned Spam Act that countered the alarming rise of unsolicited spam email messages that interfered with the use of Internet and email by end users. Today, technology has continued its progress, and as a result, we're once again confronted with challenges of protecting consumers and ensuring that private data is not shared without consent. The ability to easily aggregate and share information over the Internet has provided tremendous benefits to our society and our economy, and the collection of consumer information can provide tremendous benefits to small and upstart businesses by allowing them to target customers that have tendencies to purchase individualized products or services. One problem, however, is that these aren't the only ones using the data, and the ability and entities that sell this information to collect such a wide variety of information on individuals is extremely troubling, because it allows bad actors to target vulnerable individuals based on very specific and granular data that has been collected across a number of online and offline platforms. We have laws that regulate how this information can be used by financial institutions in relating to medical record privacy, but outside these defined areas, the information is largely unregulated and has a potential for being tremendously harmful to consumers. I'm pleased that our committee is confronting these challenges head-on. It's important that we examine methods to introduce transparency into the system and give consumers the ability to have control over the large-scale data collection that is currently occurring, and most times without their knowledge. And I look forward to hearing the testimony from our witnesses. Mr. Chairman, I yield back.
Mr. Lala is recognized for 2 minutes.
Thank you, Mr. Chairman. Meaningful legislation to protect consumers' data is important, as there have been recently high-profile incidents involving the compromise of consumer data that has increased privacy concerns. There are many benefits that the Internet provides consumers, and it is important that consumers are protected. However, as with many of the public policy issues that this subcommittee considers, there needs to be a balance between protecting consumers and overburdening companies with regulations. The collection of consumer information is a great benefit to companies to process transactions as well as to market their products. In addition, many of these companies' products are based on information that consumers submit to then obtain information specific to them. This personal information must be protected, whether it regards personal health, employment, or any other information. While it is important for companies to disclose their privacy practices, companies should not have to disclose their proprietary practices or information for collecting this information. In moving forward on either of these pieces of legislation, we need to ensure that by expanding the authority of a government agency, that there are no unintended consequences on e-commerce. I have heard concerns, especially from small businesses, about this legislation having a chilling effect on e-commerce and curbing innovation. These small businesses are concerned that increased regulations will have a negative effect on their businesses and have increased costs for them and those that are self-employed, ultimately, which will then have to be borne by the consumers. I look forward to continue to work with the subcommittee on this important issue relating to protecting consumers' privacy. In this time of rapidly advancing technology, we must protect personal information. I am hoping that this balance can be achieved for all the parties involved. And with that, Mr. Chairman, I yield back. Thank you.
The chair recognizes Mr. Stearns for 5 minutes.
Thank you, Mr. Chairman. And like other members, I'm very glad we're having a hearing on H.R. 5777, Best Practices Act, as well as the proposal drafted by Mr. Boucher, the chairman of the Communication Technology and the Internet Subcommittee, the CTI Subcommittee. I was a sponsor, a principal sponsor with Mr. Boucher on his bill. And so I'm happy to join with him in soliciting comments, as he did over some 70 days. As many of you perhaps know, that I've had a lot of experience working on this privacy issue. It's complex, involves a broad range of interest. During my time as chairman of this subcommittee, I introduced several privacy bills, so I understand the importance of transparency when it comes to collection, use, and sharing of consumer information. Now, it's my capacity as the CTI subcommittee, I've been focusing on privacy issues and the Internet, which has become so ubiquitous in our everyday lives that we have started to presume a certain level of privacy that may not actually exist. So that's why I think we should be looking at this privacy situation. We must recognize that online advertising supports much of the commercial content, applications, and services that are available on the Internet today without charge. And, my colleagues, we do not want to disrupt this well-established and successful business model. Now, this bill, Best Practices, seeks to enhance transparency over the commercial use of personal information and provides consumers with choices about the collection, use, and disclosure of this information. I support providing consumers with choices and transparency, but we must also keep in mind that only the consumer knows how he or she feels about the information that's being collected, the parties doing the collecting, and the purpose for which the information is ultimately collected. Congress cannot and should not make that decision for them. Now, I do have some concern with this Best Practices Act as currently drafted, including the overly expansive definition of covered information, the private right of action with uncapped punitive damages, and the safe harbor provision, which is too prescriptive and relies too heavily on the Federal Trade Commission. In order to have an effective safe harbor and privacy legislation, we must craft a provision that creates the right incentives for businesses to subscribe to the very best practices with respect to the use of personal information of those consumers. Standards that have been developed over time and are capable of being modified rapidly to address any new, significant consumer privacy concern about businesses' use of consumers' data. I'd like to work with my colleagues to develop a better self-regulatory structure that will protect consumers while creating the proper incentives for businesses to adopt and maintain the best privacy protection standards. I obviously appreciate having these hearings. I regret, though, Mr. Chairman, we're having a hearing only 4 days after the bill was publicly released. This is an important and complicated topic, and members and staff and our witnesses need more time to adequately analyze the provisions in this legislation. It's a credit to Mr. Boucher. He released his privacy discussion draft on May 4th, and he allowed ample time for comments. And if I recollect correctly, there were 70 different organizations, companies, universities, colleges, and concerned citizens that have taken the time to send their comments on this discussion draft. So we have plenty of information to consider for his bill. So there's clearly a lot of interest out in the industry for privacy legislation. I feel that more time allowed for more robust discussion is necessary, so I hope we have that in the future. But again, I appreciate your work and the leadership on this issue, and also Mr. Boucher's hard work, as I look forward to working with members of both subcommittees as we try to find the good, equal balance of protecting consumers and allowing innovation to flourish. I'll just conclude to sort of mention what Mr. Scalise mentioned a little bit about the FCC and their haste to move from Title I to Title II, the Internet jurisdiction. And I would say that one thing I would add to his comment is when we get back in September, it'll only be a couple of days, perhaps, until the FCC acts, and that's really not enough time for us to even consider what they're doing. So, again, I urge, as Mr. Scalise did, that the FCC hold off. Thank you, Mr. Chairman.
The Chair thanks all of the members for their opening statements, and the Chair do want to reassure every member of this subcommittee that the time necessary for deliberation will be forthcoming, and that in no way do we expect to rush, pardon the pun, to rush toward judgment. However, we do feel as though we need to start this process in a robust way, in a robust manner, and that's what was the intention of the chairman. Discussions got to end sometime, and now is the time for the discussions to end and the work to begin. So, with that said, I want to welcome our witnesses now, and I am so honored that these individuals have taken the time out from their busy schedule to come and share with this subcommittee their valuable information, insight, and their expertise on this most important matter that faces the American people. I will introduce them now. From my left is Mr. David Fladek, Vladek.
Vladek.
He's the director of the Bureau of Consumer Protection for the Federal Trade Commission. Seated next to Mr. Vladek is Ms. Leslie Harris. She is the president and CEO of the Center for Democracy and Technology. Next to Ms. Harris is Mr. David Hoffman. He's the Global Privacy Officer for the Intel Corporation. Seated next to Mr. Hoffman is Mr. Ed Merzinski. He's the Consumer Program Director for the U.S. Public Interest Research Group. And next to Mr. Merzinski is Mr. Ira Rubenstein. He's the adjunct professor of law at the New York School of Law. And next to Mr. Rubenstein is Mr. Jason Goldman. He's the Counsel, Technology, and E-Commerce for the U.S. Chamber of Commerce. And then we have seated next to Mr. Goldman is Mr. Mike Zanis. And Mr. Zanis is the Vice President of the Public Policy Interactive Advertising Bureau. Again, thank you all so very much for being present here at this hearing. It is the practice of this subcommittee to swear in the witnesses. And I ask each of you if you would stand and raise your right hand.
We'll get there.
We'll get there.
Yeah, all right. There's a big panel of witnesses we got here. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please let the record reflect that the witnesses have all answered in the affirmative. And now we'll begin with testimony from our witnesses. We'll begin with Mr. Vladek. Mr. Vladek, you're recognized for 5 minutes.
Thank you very much, Chairman Rush, Member Winfield, members of the committee. I really appreciate the opportunity to be here today. The Federal Trade Commission has a long track record of protecting consumer privacy. The Commission began examining online privacy in the mid-1990s. Initially, the Commission's work was built on the so-called fair information practice principles of notice, choice, access, and security. The Commission's efforts were widely credited with raising public awareness about privacy, prompting companies to post privacy policies online for the first time, and improving companies' accountability for privacy practices. In the early 2000s, the FTC shifted its focus and targeted harmful uses of information, uses presenting risks to physical security, economic injury, or causing unwarranted intrusions. This approach was designed to protect privacy without imposing costly notice and choice requirements for all uses of information. The Commission's privacy agenda included aggressive enforcement on data security, children's privacy, spam, spyware, and unwanted telephone calls, telemarketing robocalls. Last year, the Commission announced that it was going to again reevaluate its approach to privacy. We recognize that the traditional models governing consumer privacy have limitations. The Fair Information Practices model placed a heavy burden on consumers to read and understand complicated and lengthy privacy policies, and then make choices about the collection and use of their data. The harm-based model generally did not address concerns about having one's personal information exposed where there is no direct and tangible consequence. Often, harms to consumers were addressed after they occurred. Late last year, the Commission began its reevaluation of privacy by holding 3 roundtables, which highlighted a number of important themes. First and most urgently, consumers do not understand the extent to which companies are collecting and using their personal data. This is a remark that I think many of the members echoed in their opening remarks. Second, existing privacy policies don't work as a means of communicating privacy practices to consumers, and certainly will not work well on small screen mobile devices like smartphones. Third, consumers do care about privacy, and they care about privacy as a value in and of itself, beyond any tangible economic harm that may be associated with it. And finally, as others have pointed out, the free flow of information does help make tremendous benefits possible. So we need to be cautious about restricting information exchanges and uses. Recognizing many of these same issues, Chairman Rush and Chairman Boucher each have proposed legislation to advance the goal of improving privacy protection in today's commercial marketplace. We share this goal, and we applaud Chairman Rush and Chairman Boucher for their leadership. Although the Commission has not taken a position on the legislation, both proposals include a number of key policy objectives that the Commission supports. First, both include requirements for data security for customer information, a requirement the Commission has long endorsed. Second, the Commission supports the proposal's data accuracy requirements, especially where the data will be used for decisions about a consumer's eligibility for benefits or services. Third, both proposals give the FTC limited rulemaking authority in the privacy area. We believe that the content, timing, and scope of privacy disclosures required by the legislation will benefit from broad stakeholder input and consumer testing, which can be accomplished as part of an APA rulemaking proceeding. Finally, both proposals include innovations to simplify consumers' ability to exercise meaningful privacy choice. If Congress enacts legislation in this area, we urge it to consider some additional issues. Most importantly, we think it would be useful to require short disclosures at the point of information collective and/or use, and to give the FTC rulemaking authority so it can provide guidance on this requirement. Let me share an example of why we think short and concise notices at the right moment are important. A few months ago, it was reported that approximately 7,500 consumers had, quote, sold their souls, close quote, to an online computer game retailer. To drive home the point that consumers don't read lengthy disclosures, the company included a provision in its privacy policy that by placing an order with the company, the consumer granted the company, and now I'm quoting, a non-transferable option to claim for now and forevermore your immortal soul. The company even went on to provide an opt-out provision for this particular soul-settling clause. But not surprisingly, very few consumers opted out. Now, I don't believe that these consumers really meant to transfer their right to their immortal soul to an online gaming company. And we think this illustration drives home the need for short and concise notices that consumers will read and understand at the time of data collection and use. Another issue we would urge Congress to look at is whether the sharing of individuals' data among companies affiliated through common ownership should necessarily be exempt from consent requirements, especially where a company may share data with dozens or even hundreds of affiliate companies. Finally, we also have concerns that the safe harbor programs contained in the proposed legislation could lead to multiple consent mechanisms that may differ in important ways, which could add to consumer confusion when consumers need more simplicity. The Commission looks forward to working with Congress to resolve these issues and any others that may arise in order to accomplish our shared objective of improving consumer privacy, while at the same time promoting innovation and beneficial flows of information on the Internet. Thank you very much.
The Chair now recognizes Ms. Harris for 5 minutes.
Chairman Rush, Ranking Member Whitfield, members of the subcommittee. On behalf of CDT, I thank you for the opportunity to testify today. Chairman Rush, you, Chairman Boucher, Representative Stearns have shown great leadership in putting the issue of consumer privacy legislation back on the congressional agenda at a time where more and more personal information is collected, analyzed, and sold. An astonishing 88% of Americans are concerned about their online privacy. A consumer privacy law is long overdue. Drafting a privacy law that can stand the test of time requires a careful balancing of interests. The law must provide consumers' rights, It must provide meaningful obligations for companies, but at the same time it has to be flexible and high level enough to respond to the rapid changes in technology and changing business models. It needs to give companies certainty while at the same time encouraging privacy innovation and accountable practices. And of course, it needs strong enforcement. CDT believes the bills before the subcommittee today include the essential building blocks for a privacy law that meets this test. Chairman Boucher's draft took critical first steps to that end. We believe the Best Practices Act builds on that draft to significantly advance the discussion. Let me just mention a few key points. Fair information practices, commonly known as FIPS, must be the foundation of any consumer privacy law. The Boucher draft provides the basic obligations and notice and choice and security, but as Mr. Vladeck said, that places most of the burden on the consumer to figure out notices. Best practices goes further to a full set of substantive fair information practices that place obligations on companies for things like specifying purposes, limiting data collection to those purposes, minimizing how long one retains data, paying attention to data quality and integrity. And we think that in this complex environment, all of those obligations are critical. With respect to scope, CDT does support the application of a single baseline set of rules to the online and offline environment. We do support a robust definition of covered information and heightened protection for sensitive information, and we strongly support the special rules for covered entities, right now mainly ISPs, that collect all or substantially all of an individual's data stream. We are pleased with the innovative provision on accountability in best practices, which requires companies to conduct PIAs, privacy impact assessments, and periodic reviews of privacy practices. American companies, including my colleague from Intel, HP, and Microsoft, have been the global leaders in developing an accountable privacy culture within companies, and we think this provision will broaden the culture of responsibility for all covered entities. We also strongly support the inclusion of a safe harbor provision. Safe harbors, when they are backed up by rigorous internal compliance and some FTC supervision, can take account of differences between industries, can create certainty for companies, it can encourage privacy innovation, and reward the adoption of accountable practices. Finally, strong enforcement must back up privacy rules, and we endorse the dual enforcement regime at the FTC and with the state attorneys general. And we also applaud the inclusion of a strong private right of action in the best practices bill. Mr. Chairman, thank you for the opportunity to testify and holding this important hearing. We intend to submit a lengthy side-by-side of the bills and our recommendations for moving forward, and we look forward to working with you to enact historic privacy legislation that consumers are strongly demanding and that we believe businesses need to compete in the global economy.
The chair recognizes Mr. Hoffman for 5 minutes.
Mr. Chairman, Ranking Member Whitfield, and members of the subcommittee, I'm David Hoffman, Director of Security Policy and Global Privacy Officer at Intel Corporation, and I appreciate the opportunity to testify before you today. Intel supports the Best Practices Act of 2010, and we believe that innovation requires a policy environment in which individuals feel confident that their privacy interests are protected. We thank Chairman Boucher and Ranking Member Stearns for putting forward such a thoughtful and important draft from which to work. Their bill and the Best Practices Act include many of the important concepts for a comprehensive U.S. privacy law, and we strongly support Congress's efforts to legislate in this area. I congratulate you on the work you have done to protect consumer privacy and to promote continued technology innovation. It is Intel's mission to deliver the platform and technology advancements that have become essential to the way we work and live. We see computing moving in a direction where an individual's applications and data will move as that person moves through his or her day. To manage these applications and data, the individual will use a wide assortment of digital devices, including servers, laptop computers, smartphones, tablets, televisions, and handheld PCs. Thus, it is necessary that individuals have trust in being able to create, process, and share all types of data, including data that may be quite sensitive, such as health and financial information. The provisions in the bills we are discussing today can help provide a policy environment which creates that trust. I would like to highlight 5 specific aspects of the 2 bills. First, we are pleased that both bills are technology neutral and give flexibility to the FTC to adapt the bill's principles to changes in the technology. Maintaining technology neutrality in the legal framework provides protection for individuals in a rapidly evolving society, as the creation of legislative and regulatory requirements will invariably trail innovation of new technology. We specifically like the Best Practices Act's guidance given for the FTC to create regulations for certain key provisions of the bill. Second, we support federal legislation based upon the fair information practices as articulated in the 1980 OECD Privacy Guidelines. We are pleased that the Boucher-Stearns discussion draft is based upon the framework of the fair information practices. Further, we are supportive of Chairman Rush's bill, which goes further and includes provisions applying all of the fair information practices, such as individual access to data, data minimization, and purpose specification. Third, we are pleased that the Best Practices Act includes a provision requiring covered entities to engage in accountability processes in the deployment of technologies and services. In addition, we would advocate that a specific privacy by design requirement also be included in the accountability section. A privacy by design model focuses on ensuring that privacy is included as a foundational component of the product and service development process. Such a provision should not require compliance with detailed standards or mandatory third-party product reviews, but should instead focus on including privacy into a business's product and service development processes. Fourth, Intel commends both bills for contemplating that certain operational uses of data are implicitly consented to by individuals and should not require explicit notice and consent. Specifically, Intel supports the Best Practices Act's drafting of such a use-based model. Fifth and finally, Intel is strongly supportive of Title IV of the Best Practices Act, which establishes a safe harbor for participation in self-regulatory choice programs. Intel has long been a supporter of privacy trust mark programs and believes they provide a way to work with organizations on their accountability processes. We believe that in many instances, trust marks and other similar mechanisms can substantially increase the reach and the effectiveness of government enforcement. This co-regulation is a better solution than a private right of action, which is likely to result in baseless claims, causing organizations to expend resources on litigation when those resources could be better directed toward the organization's privacy compliance program. However, if a private right of action is included, then the choice program should continue to provide a safe harbor from liability. Intel again thanks Chairman Rush and the subcommittee for your excellent work to protect consumer privacy and to promote continued technology innovation. We are supportive of the Best Practices Act. We look forward to continuing our engagement to improve the overall protection of privacy.
Thank you. Mr. Brzezinski, you're recognized for 5 minutes.
Thank you very much. Thank you very much, Chairman Rush and Ranking Member. I was trying to work my timer. This one's not working, but I'll try to stick to 5 minutes. Ranking Member Whitfield, members of the committee. I am Ed Brzezinski. I'm Consumer Program Director for the Public Interest Research Group, U.S. PIRG. My testimony as submitted includes co-signed by the Consumer Federation of America and the Center for Digital Democracy. Since then, 4 other organizations, and I'll provide this for the record: Consumer Action, the Consumer Watchdog, Privacy Rights Clearinghouse, and the World Privacy Forum have also endorsed the testimony. I want to start out with one point that is really the main point that I want to make, and that is that the current digital marketing system does not meet consumers' expectations of privacy. A recent study by 2 leading universities, University of Pennsylvania and University of California at Berkeley, found that most consumers believe that the government already protects their privacy. It does not. Instead, we have a digital marketing system that I could call the Hoover model, and I'm not talking about J. Edgar. I'm talking about the vacuum cleaner. The vacuum cleaner model of collecting every bit of information, every web track that a consumer ever makes, and keeping it forever is the way that companies like in their virtually unregulated digital ecosystem. We have a system right now where the Federal Trade Commission has been hobbled for 30 or 40 years by limits on its ability to improve the rules that and enforce the rules by the Magnuson-Moss rulemaking that was imposed on it that this committee tried to fix in the Wall Street Reform Act, but unfortunately the Wall Street Reform Act did not finally give the Federal Trade Commission full APA rulemaking authority or full aiding and abetting liability or the full ability to impose civil penalties. And we would hope that that would be on the committee's agenda to continue to try to achieve those goals. But so our organizations share longstanding concerns for consumer privacy and look forward to working with the committee on these matters. And the committee has had a long-standing history of bipartisan basis working on consumer privacy, so we're very encouraged by the work that was done first by Chairman Boucher and Ranking Member Stearns, and then by you, Chairman Rush, in putting together your thoughtful proposals. However, our concern is that the proposals tend to graft fair information practices on top of the digital ecosystem, that it just won't work as well as a full fair information practices based provision might work. So we're suggesting that the committee start over, and among the key elements of a revised bill would be a framework focused on overall data minimization. Anyone who knows the online and offline data collection industry will tell you that the focus is on data maximization, as I said, the Hoover model. Every move you make, as the lyrics of the Police song go, could be the data collection industry's theme song, as we are all being watched, compiled, analyzed, and then acted upon. While tools involving opt-in and safe harbors, for example, provide greater control by a consumer, they do not constrain the dramatic and far-reaching growth of online and offline data collection for personalized and innovative targeting. A vast, automated, and powerful data collection complex has emerged, capable of generating and continually revising a profile, a consumer X-ray, of our habits, interests, worries, financial status, and everything else about us. It is now being collected not just on the Internet, but also whenever we use a cell phone or play an online game or use any other variety of electronic gimmickry that we might be carrying around with us. Some of the specific concerns that we have, again, we think the bills are a thoughtful first start, but we would urge you to consider a few other things. First of all, notice and choice are not enough, and I totally agree with the other witnesses that these bills go further than the industry-preferred FIPS light of notice and choice. But we need to have a greater reliance on limiting the amount of information that is collected, used, and shared, increasing the knowledge of consumers, limiting data retention, and maximizing data minimization. The second, self-regulation has not worked. The Federal Trade Commission, under various administrations, has failed in self-regulation, as has the industry. And there are several reports that I cite in my testimony that go through the details of how, first, the individual references services group self-regulatory body that supposedly regulated information brokers didn't work in the 1990s. Then we have the Network Advertising Initiative didn't work. And there is an IAB provision that was started last year that we don't think has worked. So we think we need greater oversight, greater statutory protections. And we need a broader private right of action. Although the Rush bill has a narrow private right of action, we don't think private rights of action enrich trial lawyers. We think private rights of action deter lawlessness, and they encourage companies to comply with the law. And second, we believe that state laws should always be allowed to be stronger than federal law. If you've got a good enough federal law, the states will move on and do other things. But if Congress doesn't solve the job, we need the states as quick responders to new problems. With that, I'll just conclude my comments and tell you that I'm very pleased for our organizations want to continue to work with you to refine and enhance this legislation. Thank you.
Thank you. Mr. Rubenstein, you're recognized for 5 minutes.
Mr. Chairman, Ranking Member Whitfield, and members of the subcommittee, thank you for the opportunity to testify today. My name is Ira Rubenstein, and I'm an adjunct professor at NYU School of Law. This afternoon, I will focus my comments specifically on a key question in congressional efforts to regulate privacy. What is the relationship between privacy legislation and industry self-regulation, and the role and effectiveness of safe harbor provisions in promoting self-regulation.
Would you pull it closer to you? Thank you.
A safe harbor is a familiar legislative device intended to shield or reward firms if they engage in desirable behavior as defined by statute. In the privacy arena, the most familiar example is the Children's Online Privacy Protection Act. Over the past decade, COPPA safe harbor programs have met with success mainly in terms of complementing FTC's own enforcement efforts. But the program has two main shortcomings: weak incentives and a low rate of participation. Only about 100 firms have joined. In my written testimony, I propose several ways in which Congress might improve upon the COPPA safe harbor by adopting a more co-regulatory approach, in which industry enjoys greater scope in shaping self-regulatory guidelines, while government sets default requirements and retains general oversight authority to approve and enforce such guidelines. A co-regulatory approach relies on both sticks and carrots as incentives. Sticks for non-participating firms might include a private right of action, broader opt-in requirements, external and independent audits of regulatory compliance, and much stricter requirements for online behavioral advertising. Carrots, on the other hand, might include not only exemptions from private actions for safe harbor participants, but also cost savings, such as compliance reviews based on self-assessments rather than external audits, government recognition of better performing firms, and regulatory flexibility in the form of tailored requirements addressed to specific sectors or business models. In proposing this new approach to privacy safe harbors, it bears emphasizing that safe harbor benefits should be limited to firms demonstrating superior performance and would not be available to other firms that merely satisfy default statutory requirements. In other words, a safe harbor would only benefit firms that meet high performance standards based on, for example, sound data governance practices, such as appointing a chief privacy officer who is accountable for setting privacy protection policy and standards, advanced privacy methodologies, such as the use of development guidelines for building privacy protection into products or services, also called privacy by design, as Mr. Hoffman mentioned, and other best practices, such as privacy training for relevant staff and online guidance on privacy and security issues for other employees and for consumers. In closing, I want to emphasize that this new approach to privacy safe harbors should not be confused with existing self-regulatory schemes in which industry alone develops and then oversees a privacy code of conduct. Rather, in a privacy safe harbor as envisioned here, the government sets default requirements and relevant standards, and practices emerge from a multi-stakeholder process in which both advocacy groups and members of the public have an opportunity to participate. This requires that interested parties engage in difficult and perhaps protracted negotiations and keep talking with each other until they forge a rough consensus. One way to ensure public participation is negotiated rulemaking, a statutorily defined process by which agencies formally negotiate rules with regulated industries and other stakeholders as an alternative to conventional rulemaking. An alternative approach would be to modify the safe harbor approval process by requiring that program sponsors engage in a public consultation and report on these consultations in their applications. I will conclude by offering 3 recommendations which I'm happy to elaborate upon during this hearing. First, Congress needs to enact comprehensive privacy legislation incorporating robust fair information practices. Second, this legislation should include a safe harbor program based on a co-regulatory approach as described above. Finally, this safe harbor program should include strong performance standards based on data governance, advanced privacy methodologies, and other best practices, and it should also require public consultation as part of the safe harbor approval process. The 2 bills being considered today represent important first steps in developing this new approach to safe harbors, but should be expanded as discussed above. I want to thank you again for this opportunity to testify. I will be pleased to answer your questions and would be happy to provide any further assistance.
Mr. Zanis, you are recognized for 5 minutes.
You want to? Happy to do it.
I'm sorry.
That's all right. We don't want to skip over Jason.
Mr. Goldman, I'm sorry. Mr. Goldman.
Thanks very much.
Recognized for 5 minutes.
Good afternoon, Chairman Rush, Ranking Member Whitfield, and members of the subcommittee. I am Jason Goldman, Telecommunications and E-Commerce Counsel at the U.S. Chamber of Commerce. The U.S. Chamber of Commerce is the world's largest business federation, representing the interests of more than 3 million businesses and organizations of every size, sector, and region. On behalf of the Chamber and its members, I thank the subcommittee for its work on consumer protection and for the opportunity to testify here today. Privacy is a key issue for the Chamber. The Chamber supports policies that foster business opportunities while respecting consumers' privacy. The collection of personal information is necessary to provide consumer, social, and business benefits. Given the diversity of the private sector, business should have latitude within acceptable guidelines in defining what they need, what kind of information they need to collect and use. Recently, the debate over privacy has been brought to the forefront by the growth of the Internet. The Internet has revolutionized the way business is conducted in all sectors of the global economy, including financial services, retail, wholesale distribution, and manufacturing. Today, the vast majority of companies, small and large, are online and use the Internet to communicate with consumers and with the vendors and different other entities. In particular, ad-supported content has been key to the success of broadband. Frequently, online content is provided free of charge to consumers, and revenues are instead generated through advertising. This ad-supported business model has been a key to the success of many Internet ventures and has helped to make the Internet an engine of growth in the U.S. economy. I will now turn to the bills that are the topic of this hearing. The Chamber received the text of the Best Practices Act just a few days ago, so my comments today are based on our initial read of the bill and may change as we further analyze the bill and vet the bill through our membership. The Chamber's analysis of the Boucher Stearns discussion draft was submitted to their subcommittee in June and is attached to our testimony. The Chamber very much appreciates the work that went into drafting the Best Practices Act. Despite the inclusion of some provisions that we support, we still have strong concerns with the bill as currently drafted. The Chamber, I'll go through some of the provisions that we support and also some of the ones that we have modifications to. The Chamber is pleased that the bill directs the FTC to promulgate rules under this Act in a technology-neutral manner. Government should not pick winners and losers. The Chamber applauds the inclusion of language that preempts state laws governing the collection and the use of data. However, the Chamber believes this language could have been even stronger to help businesses avoid having to comply with 50 different state laws. The Chamber agrees with the intent of Section 502, which states that the bill should have no effect on activities covered by other federal privacy laws. However, the opening clause of this section states, except as provided expressly in this Act. This could be interpreted by the FTC or by the courts as permitting the creation of multiple layers of regulation. The Chamber appreciates that the bill attempts to maximize regulatory flexibility. However, at the same time, the Chamber is concerned that the sheer number of rulemakings will create needless regulatory uncertainty. The Chamber also believes that the safe harbor provision as drafted is a good start, but improvements could be made. We are gratified by the recognition that industry self-regulation in this area has and will continue to protect consumers. However, the safe harbor, in our opinion, is too narrow and should follow FTC and industry principles. Also, the Chamber has serious concerns about private right of action, as well as an explicit grant of authority to state attorneys general to enforce the legislation. When combined with the FTC's own enforcement authority, we are concerned that these additional mechanisms will serve to impose duplicative and potentially inconsistent findings of liability, as well as excessive damage awards. In addition, the explicit grant of authority for the award of punitive damages and attorney's fees will serve to increase the likelihood that elements of the plaintiff's class action trial bar will use this legislation as a way to increase class action litigation with little benefit being given to the general public. The Chamber also has some concerns, covered in more detail in our testimony, with the opt-in requirements for third-party sharing and opt-out requirements for information collection, as these provisions could upset established business practices for many of our members. Finally, the Chamber has concerns with access and dispute resolution and the definition of covered information, which I'll be happy to discuss further during our Q&A. Thank you again, and I'm happy to answer your questions following Mr. Zanis.
Mr. Zanis, please, for 5 minutes now.
Thank you. I used to work for the U.S. Chamber of Commerce, but I don't think they would appreciate me delivering their testimony here today. Thank you, Chairman Rush, Ranking Member Whitfield, members of the subcommittee for holding this hearing for the opportunity to testify about these important legislative proposals. My name is Mike Zanis, and I do work for the Interactive Advertising Bureau as Vice President of Public Policy. The IAB represents some 460 companies involved in online advertising. Our companies run the gamut from the largest portals and search engines to branded publishers. It includes ad networks, all the way down to the smallest mom-and-pop shop publisher online. The common theme for all of these folks is that they depend upon online advertising. It's a good industry, and we continue to grow, even in these tough economic times. In the first quarter of this year, online advertising revenue in the U.S. grew to $6 billion, and that represents a 7.5% increase over the first quarter of 2009. More importantly, our industry is a major component of the national economy. We add more than $300 billion to the U.S. economy and provide more than 3.1 million jobs total. But we know it's not all about economic numbers here today. We know in our industry that the number one asset that any company has is the consumer relationship and building trust through protecting their privacy and meeting their privacy expectations. That's why our industry has a long, successful history of strong self-regulation. It began over a decade ago with input from the Federal Trade Commission when industry stood up the Network Advertising Initiative. And this was a program to oversee third-party ad networks and how they collected and used data for consumers and provided choice. But we knew over time as our industry grew and innovated, then so too did our self-regulatory programs. They needed to innovate and grow and expand. That's why over 2 years ago, IAB joined with the Association of National Advertisers, the American Association of Advertising Agencies, the Direct Marketing Association, and in conjunction with the Council of Better Business Bureaus, one of the most respected, reputable self-regulatory monitoring and compliance programs in the world, to create for the first time a broad, comprehensive set of online privacy practices for advertising purposes. Here, too, we took away lessons from the Federal Trade Commission. They issued their staff report about online behavioral advertising privacy principles in February of 2009. We incorporated many of those principles in our in our final principles that were issued in July of last year, including transparency, consumer notice, and something that we haven't talked about, which is consumer education, which is really a key component here. All of this leads me to the bills and the legislative proposals that are on the table today. And, Mr. Chairman, I want to thank you for your recognition in H.R. 5777 about the importance of industry self-regulation. We think that that's the right approach in that it has a long history of success, it can be more flexible and dynamic, and there's a commitment by industry and government agencies to make sure that it works. And we stand ready to work with you to make sure that any legislation that moves forward reflects upon and bolsters the success that not only the FTC has pushed out there and achieved, but that industry and our cross-industry self-regulatory group. We're beginning to see fundamental change online already in this marketplace about how consumers receive information, about how data is collected and used, and pushing choice out ubiquitously. That leads me to my second point. Then we are very gratified to see your recognition in the bill that a one-size-fits-all consumer notice jammed down in a privacy policy that often is written in legalese may not serve consumers all that well. In fact, in our industry, we're seeing a tremendous amount of innovation in better ways to serve notice to consumers. And we hope to preserve that type of flexibility with any legislation that moves. But, and there's always a but, we do have a number of reservations about H.R. 5777 and Congressman Boucher's proposal. And they share a couple of components, and I'd like to just identify here. The first is the concept that first-party data usage requires an opt-out. Here we simply have to agree with the Federal Trade Commission's finding in their staff report. When consumers go to an online website, they understand there's going to be a certain amount of data exchange by that first-party site then to serve them content and services and, yes, advertising. And so we think that they should be clearly first-party usage should be exempted out of this choice mechanism, not notice. We should always do better around giving consumers notice about how the data is collected and used. The second issue I'd like to raise with you is the third-party data sharing provision. The Internet is nothing but a series of third-party relationships. Virtually every website requires these third-party data sharing, whether it's to customize content, to run your analytics on the backside to make sure you know who's coming to your site and getting paid, or whether it's for relevant advertising. And so here again, we agree with the FTC's principle in their staff report that you should have an opt-out requirement, empowering consumers to exercise their choice when they have legitimate concerns around privacy. You need to give them good notice, you need to empower them, and you need to educate them, which is something that the IAB is committed to. So I'll just sort of leave you with this last thought, and I look forward to your questions. I think it's impossible to take information out of the information age, because if you do that, what you're going to get is less relevant advertising. And less relevant advertising, by definition, is spam. I don't think anybody wants that. That's not good for consumers, and it's not good for business. Thank you.
The Chair, I want to thank all the witnesses for their outstanding testimony today. A vote now occurs on the floor of the House of Representatives. There are 2 votes. It should be probably about 30 minutes or more, around 30 minutes. So it's the Chair's intention to recess the subcommittee and to reconvene immediately after the last vote takes place. And so it'll be about in half an hour. So I apologize for the interruption of this hearing, but we will be back as soon as we can. The subcommittee now stands in recess.
What's up, Mike? Thanks. Good job.
Okay. What happened? That was you and for real? Oh, I thought you were doing for real. He's like.
Incredible that he went to the Garden of Washington D.C. for future NFL players.
I found that out today at the same time you did.
So we've got procedure, right? Okay. So the first one is rulemaking authority.
Right. Covered or sensitive?
Neither. The general.
Oh, the 17.
This one. This
you
one.
pull this apart. Okay.
All right. So this is the one because the Republicans are all attacking this, and he's industry and he agrees with the approach. Okay. I think that's a good one. I think that's too long for him, so let's not get it. He needs a short one. stayed away from the thing. I called him out on his testimony. That was wrong.
That's wrong.
I was pissed off. So they know that.
There have been no state class action.
Right.
Hold on, I gotta plug mine in too.
Yeah, take your time. Eat your M&Ms or whatever they are.
We're gonna wrap this one up so you can get home.
That's right. You're going to Chicago tonight?
Yeah. I'm on at 7:30. Where's my staff at now? Well, it's something when they. The committee will reconvene and return to order. The chair recognizes himself for 5 minutes for the purposes of questioning the witnesses. Mr. Hoffman, I was interested in your testimony. And in your testimony, you highlighted the importance of providing FTC with rulemaking authority to flesh out certain requirements of the Best Practices Act and to adapt the bill's provisions to changes in technology. Other stakeholders have raised concern that providing the FTC with this type of rulemaking authority in the bill will create enormous regulatory uncertainty that is bad for commerce. What are your thoughts on this? If the FTC is not provided with rulemaking authority, will the bill quickly become outdated? Are you concerned about regulatory uncertainty? Would you answer those questions for me, please?
We think the Best Practices Act does an excellent job of not just providing rulemaking authority to the FTC, but guiding that rulemaking authority by certain criteria that should have to shape the regulations that would emanate from the FTC. Our perspective when we look at privacy legislation is to allow privacy to continue to actually aid innovation instead of impede innovation. Individual pieces of legislation need to be technologically neutral to allow for the enforcement agencies to apply those principles to the individual new business models when they come up, and to provide guidance in that way. The FTC has been an absolute leader in doing that for the past decade. Mr. Vladeck mentioned the various methods that they have used to do that, with the different enforcement actions that they've taken, plus the roundtables that they've held and how they've communicated with industry and academics. We think that the Best Practices Act balances those different interests very well.
Ms. Harris, is the approach to FTC rulemaking in this act good for consumers, and is it good for business also?
We think so. You're always, when you're writing a bill like this, you can be highly specific, and the bill will lock in today's business practices. It will not have the flexibility that you need for business practices that we haven't seen, and it will not allow the law to basically live in a way that will address business practices we haven't seen. Giving the FTC very specific rulemaking authority here, first of all, allows them to take into account the different kinds of business models and technologies that we're dealing with, but it also, I think, allows over time for modifications depending on changed circumstances. So yes, we think FTC rulemaking is essential here.
In past legislation, a third party or an unaffiliated party has been defined based on the corporate structure of an entity, such as common ownership or corporate control. And during this hearing and in other sidebar conversations, we've heard that concerns that consumers may not understand which entities are subsidiaries, affiliates, parent corporations, or otherwise under common control with another company. On the other hand, corporate structure is known, and we don't want to draw an arbitrary line. Ms. Harris and Mr. Brzezinski, do you believe that consumers may have difficulty understanding when entities are related by common ownership or control? Should privacy legislation take into account the best reasonable expectation of a consumer, as this act does, and is this a workable definition? Lastly, you can answer these three questions in the manner that you would choose to. Lastly, what are the benefits of an approach based on common ownership or control? Does it provide companies with more clarity? So those are a series of questions. Hopefully you can kind of summarize the questions in your answers.
I'm going to let Ed go first.
Thank you, Chairman Rush. And I think I want to commend you on your provision recognizing that the artificial distinction of this corporate common control, consumers don't have any idea that their bank owns some hundreds or thousands of other affiliated entities, and the Internet has a number of networked companies that are the same way. So going to an activities-based definition rather than a corporate ownership definition, we support that, and I think it's much closer to consumer expectations that, except for the company you're doing business with, pretty much everyone else is a third party.
So I generally agree. I do think that that your bill probably gets it as close to right as you can, because it's a complicated issue, and I'm glad that there's some room for FTC rulemaking on that provision. You know, the key question here is, would a consumer under reasonable circumstances believe that they're dealing with an entity that is under common control. And I really think that that's probably has to do with common branding. I think most of us know that Gap and Banana Republic and Old Navy and a whole set of companies are sort of one. But given sort of large multinationals that own many different lines of business, we have to keep that very narrow in the interest of the consumer. I think you've done that.
The chair's time is concluded. Now the chair recognizes Mr. Whitfield for 5 minutes.
Thank all of you for your testimony, and trying to balance protecting privacy versus generating revenue for advertising to keep the internet the vibrant marketplace that it is. Searching the browsing history of a particular person, and can some of you, maybe Ms. Harris or Mr. Murwinski, identify for me the privacy concerns with the anonymous monitoring of web browsing history, and should that require the same level of consent of using information like Social Security number, bank account numbers, and so forth? And just give me your perspective on the differences there. And
Mr. Whitfield, the way that they're able to collect discrete pieces of browsing history are usually to tie them together with an IP address. In that instance, companies can pull them together into profiles, and they can be put together with information to identify the consumer. So in the technological environment that we're in now, the ability to bring discrete pieces of information together into an identifiable profile is simply much easier. I think there's a conversation to be had about where you draw the line, but I think that that's something that's changed dramatically from the first time that privacy legislation was introduced in Congress.
Yeah, Mr. Whitfield, I would agree, and I would say that from our perspective, one of the strongest pieces of both bills is that IP addresses are insensitive information. We're concerned that de-identified or supposedly anonymous information can be repackaged back together. There are numerous examples of that happening. And I would also point out that a recent complaint by USPIRG, the Center for Digital Democracy, and other groups talks about just how easy it is and how the technology has changed in the last few years, that consumers are being sold on a real-time basis now. They are not compiling dossiers that take even half an hour to compile. The ads are being served instantly. They're being brokered to the highest bidder. It's a very sophisticated, and little bits of information can add up very quickly.
Mr. Zanis, would you like to comment on this?
Yeah, thank you very much. Appreciate the opportunity. I think Congress has to be careful not to try to legislate the possible or the theoretical and to understand the business model. And here, actually, I disagree slightly with Leslie. It's not the vast or predominant business model to tie clickstream data back to personally identifiable information, certainly not in the online advertising space. In fact, many of the ad networks specifically, advertising networks deliver some 90% of all ads online. They're generally third-party by nature. Their business model generally is not to try to tie it back to what we would traditionally think of as personally identifiable information. Certainly there's a lot that is possible through technology, but I don't think we can legislate the possible. We ought to be looking at actual business models. And I think when we look at H.R. 5777, it actually gets closer under their definition of covered information to what we ought to be focusing on, which is things that actually are personally identifiable, not sort of anonymous in nature.
Mr. Rubenstein, since you're an academic here, do you have any comments on this? We always value academics' thoughts.
Thank you, Mr. Whitfield. I would think I would just add that it's important not to think of anonymous data as just a binary category, that it's data is either anonymous or it's non-anonymous. And the emphasis might be on specific contexts, so how much data is being assembled? What's the quantity of data? Is it being publicly shared or privately shared? What's the specific context? Rather than try to get at this through definitions that have just a black and white aspect to them.
Okay. Yes.
I'd just like to add one point on that. I think the current draft of the Best Practices Act actually recognizes that reality that Professor Rubenstein is commenting on. As an employee of a technology company, there are a number of unique identifiers in hardware and software that are used on most computing platforms. What is happening in reality, Mr. Zanis' point is a very good one, we need to look at the reality, is that it is some of those unique identifiers that are used and to correlate to a lot of this data. That could be described sometimes as personally identifiable information. Others might say, no, it's only identifying a particular device or a particular device at a point in time. That's why I actually think the definition of preference profile, which is saying that it's a list of preferences associated with an individual or with an individual's computer or other device, but then tying that to allow an exception for participation in a choice program is an excellent way to navigate the issues that even if something is not completely identifiable to a particular individual, it still could have the great potential to impact an individual.
Thank you. See, my time's already expired. It goes back quickly.
I won't need 15, Mr. Chairman. In fact, I won't even need 5. But thank you. I really don't have any questions, having come in after the votes and after your testimony. But I do want to express my appreciation to the chairman and to the ranking member for the deliberate process that we have undertaken in examining, reviewing, and modifying issues relating to privacy when it comes to access to the Internet and broadband generally. I think having all the stakeholders present and participating in this discussion is very, very important. And we see that today. We've seen it in the past, and we'll see it in the future, whether it's academia, industry, government officials, consumer advocacy groups. All of those stakeholders deserve a place at the table, and our chairman and the ranking member have offered them that. So I want to thank the witnesses today. Thank you, Mr. Chairman, and the ranking member for, again, such a deliberate and thorough analysis of an issue that is becoming increasingly important as we see the role of broadband integrated into virtually all aspects of our lives. And I yield back my time.
The Chair thanks the gentleman for his kind remarks, and the Chair will now entertain a second round of questions, and with that in mind, the Chair recognizes himself for 5 minutes. This question is addressed to Mr. Vladeck and Mrs. Zinis. Section 303 of the Act states that covered entities using covered information or censored information for any purpose for as long as there is a legitimate business or a law enforcement need. Is our rebuttal presumption, is it too vague? What would be wrong with setting a date certain restrictions, say 6 months or a year?
Mike, you want to go first? Well, the Commission has not taken a position on these issues, and we would like the opportunity to comment later on once we've had a fuller opportunity to look at this. Just generally, we believe that certain kinds of information ought to be subject to heightened protection. And so that is, the Commission has made that clear in other contexts.
We're gonna figure this out. Luckily, I represent the advertising industry, so I know how to get my message heard, even when people don't want to hear it. I think Section 303, I think one size fits all doesn't always make sense in the online space. What you see here is a diversity of opinions, but what we see in the industry is a diversity of business models. And sometimes they may need to keep information for different purposes, and what is a legitimate business purpose, I think, differs. So, I want to take that back to my members and see if it's something that they're going to be supportive of, or if there's some refinements we need to make. But as we've seen around things like consumer notice and other areas, a one-size-fits-all isn't always the best approach, but we're willing to look at that and work with the committee and you, Mr. Chairman, on that.
Yeah, Mr. Rubenstein, would you chime in on this with your opinion, please?
I would generally agree that having different time periods for different types of data or different purposes is a good idea rather than a single limit. I think the one thing that Congress should worry about, though, is companies that would retain data simply because they might have some use of it in the future. So where it's that non-specific and it's just a future business possibility, I don't think that's a sufficient reason for some unlimited period of retention.
Mm-hmm. Mr. Rubenstein and Mr. Brzezinski suggested in their testimony that the safe harbor in H.R. 577 be strengthened in several ways. I'm going to ask both gentlemen, what specific recommendations do you have for strengthening the safe harbor provisions?
Thank you, Mr. Rush. I think the bill as currently structured captures the key point that I emphasized about having a mix of carrots and sticks, and that the private right of action serves as a very significant stick or incentive for businesses to join. I think the one thing that I'd call attention to, though, is whether the Safe Harbor Choice Program has a strong enough emphasis on high performance standards. And that's why I emphasized data governance practices such as appointing a chief privacy officer or having privacy by design methodologies, so that there are other standards that a choice participant lives up to, which in effect entitles them to the exemptions that they enjoy under the choice program. And I think the question then is how to best balance that mix of exemptions on the one hand that serve as incentives to join, while ensuring that only companies engaged in a very high level of privacy protection are then entitled. Finally, I would point to the desirability of having some form of public consultation as part of this process. And one way to do that might be for a choice program as part of their application for approval to indicate what type of public consultation they've engaged in. Have they met with advocacy groups? Have they met with the public? If so, how have they addressed concerns that those groups have raised? If they haven't addressed them, why not? So that all is transparent and available to the FTC in making its evaluation of the choice program.
Mr. Chairman, I would add to that I think our concern is that many self-regulatory programs, whether under the Securities and Exchange Commission, whether under the FTC or other agencies, they work best when they have a robust legal standard, a robust statutory framework underneath, and relying on the companies themselves and rulemaking only by the FTC is usually not good enough. And we would urge you to consider strengthening the Federal Trade Commission's monitoring of the choice program and the accountability mechanisms in there. And to do that, of course, we'd also support strengthening the Federal Trade Commission in general if they need additional resources to do those kinds of things.
My time is up. The chair recognizes the ranking member.
Thank you. Is there anyone on the panel other than Mr. Goldman that believes there should not be a private right of action? Okay.
Yes, Intel does not support a private right of action. We think that in the context of privacy, in the great percentage of situations, the individual actually does not even potentially know that they've been harmed, and they don't know who actually has caused the harm until after. We think the best use of resources is to focus on mechanisms like the choice program in the way that was just articulated that really can devote those resources to organizations putting in place robust accountability mechanisms into their compliance programs. That way we'll avoid the breaches before they even happen.
And I won't take up much of your time. I couldn't agree more. I would just say then I think what we might want to focus on legislatively is strengthening the Federal Trade Commission in their enforcement, and more resources, more cops on the beat I think would be a good thing in this area.
I'm certainly not an expert in this area. In fact, I'm far from it. But I've read that the OECD's privacy protection rules, guidelines for privacy protection, are some of the most stringent in the world. Is that your understanding as well, most of you? Do you understand that to be true?
I would just say it's the understanding of privacy groups that they are the most robust implementation of the fair information practices that were actually first developed by a U.S. regulatory committee. But how they are implemented in law is different in different places. And I'd say the only U.S. law that comes close to implementing them in a very strong way is something called the Fair Credit Reporting Act, which regulates credit bureaus. Other laws rely on a much weaker version of the FIPS.
Well, I mean, if we were to adopt the OECD principles, basically, would you support that? Or?
Oh, absolutely. And I want to say that both bills adopt parts of it. And, in fact, the Best Practices Bill adopts quite a bit of the fair information practices. We think we can go further with purpose specificity, data minimization, data retention, and, again, accountability. That is giving more rights to the data subjects.
Yeah, Ms.
Mr. Whitfield, I want to agree that a strong set of fair information practices, and certainly the OECD is sort of the foundational. In the United States, the Department of Homeland Security issued a set a few years ago that I think are, perhaps capture some of the more modern concerns just a little bit, that basically a bill really needs to include them all, that we've spent a long time focusing on, opt-in, opt-out consent from the consumer. And when that's all you have in a bill, then you're pretty much telling the consumer that they've got to figure it out. They've got to read privacy policies. They've got to understand it. And that the companies don't have any substantive obligations. When you include data minimization, et cetera, then you're putting real limits, and companies have to decide how to handle this.
Mr. Murwinski, I'm sorry, go ahead.
Sorry, I want to be sure that the chairman and you, Ranking Member Whitfield, understand that there is a lot of fair information practices certainly in H.R. 5777. You're talking about notice and choice and data security and accuracy. These are fair information practice principles. That doesn't mean you need all of them in a bill about things like marketing databases. And in our written testimony, we go into the access and correction provisions. And the reality there is what we're talking about in some of these marketing databases are strings, user agent strings, which are nothing more than computers talking to computers, telling you what, for instance, operating system a person is using to go to a site. This is used to render the content readable to the consumer. I ask you, what is the purpose in allowing correction to that type of database? It's gobbledygook to the consumer, and I worry about allowing people to get into those databases when there's no real harm. We're not talking about Fair Credit Reporting Act. There you're talking about adverse actions against consumers, things centered around employment eligibility, access to credit, getting a home mortgage. It's not what we're talking about here.
May I ask one other question?
Ms. Harris wanted to respond.
Oh, I'm sorry.
I want to strongly disagree with that. Access is one of the key fair information principles. The likelihood that a consumer is going to demand access to a string of code, I think, if that's the concern, my guess is we can figure out how to handle it in this committee. But we're building larger and larger databases with all kinds of information, and to me that's one of the fundamental rights that consumers have, and that it needs to be part of this bill.
In Mr. Rush's bill, in the definitions under covered entity, it simply says engaged in interstate commerce, whatever. And since I was in the railroad industry, I know that when we talk about federal preemption, it's from a business standpoint, we always love federal preemption because we had some certainty in whatever state we operate in and so forth. And I know that a number of you would be opposed to federal preemption in this arena. Are any of you opposed to? Okay, Mr.
Well, I think we're very strongly opposed, okay. And the best practices bill is a much narrower form of preemption, but we'd prefer that federal law be a floor.
What about you, Mr. Rubenstein? Do you have a comment on that?
I would favor a narrow form of preemption. I think that it does allow businesses to operate with more certainty, and it's extremely difficult and costly and not very effective to have to design compliance programs that vary depending on which states you operate in. So I think some form of preemption is a necessary aspect of this bill.
Do you want to make a comment, Ms. Harris?
Yes, Mr. Whitfield. CDT's position is that first, the bill has to be good enough at the federal level to consider preemption. So, in saying whether we support it or don't support it, this is a messy process. Right. But assuming that the bill provides the right degree of protection, then a narrow preemption that really covers just those covered entities and just those practices is something that we are comfortable with. Okay. But, there's a threshold of what the bill is. And, right. We do think that Mr. Rush's bill gets that right.
Yeah. Well, I mean, I was assuming that if Mr. Rush pushed the bill through, it would be all right.
I want to one other question, and this question is addressed to Mr. Goldman and Ms. Harris. In your testimony earlier, you say that user IDs, identifications alone, should not be defined as covered information. And given the fact that there are software passwords, guessing tools out in the marketplace, what kind of concerns should we have? And I'm kind of pointing to a recent development among and myself and with myself and some other members of Congress. There's a certain company that have something they call street maps, and I'm really alarmed by these street maps. My residence is showing up on these street maps, and there are other members of Congress whose residence is showing up on these street maps, and we're concerned about the vulnerabilities, especially for unprotected access to the webs and internet. What kind of harm could be visited by consumers with some of these different programs? So can you respond to that, Ms. Harris and Mr. Goldman, about this particular issue?
Sure, I'll go first. I mean, I think as in our testimony, I think we talked about how if information is not directly linked back to the individual, so if it's just a password or some other kind of information that's not connected to your other kind of personal information, that should now be part of the PII. And so I think that is where we're at. You could theoretically have a lot of information out there. There's a lot of information out there. You might, for example, if you belong to a social networking site, you might put your name up there. You might create a username, but it might not be linked back to your own name, your own personal, I guess, whether it's sort of financial or health information. So I think as long as there's the question is what kind of harm is going to result from all of that. I think. And as also we go into our testimony, also talks about how we're hesitant about adopting sort of new standards and new definitions of cover information. I think to the extent that we can standardize definitions across bills, across state bills and federal bills, that would be a good thing. So if you look at personal information as defined in some of the state bills, some of the state data breach and privacy bills, I think, we haven't I think there'll be some support for that, but I haven't talked to our members about that yet.
Ms. Harris, you got a response?
If the question is about whether we should be covering passwords and unique identifiers that protect this kind of information, then I think in the right circumstances we should, and I think that your bill does do that.
Does any other witness want to respond? Mr. Hoffman,
Yeah, I think it's a very good question. I think we find ourselves in a situation where there are a number of different kinds of data that while they do not point to a very specific individual, they might point to a device or a location or something that could end up impacting that individual. This is a very difficult balance to sort out. I actually think the best practices act comes very close to getting this as right as you possibly can. We're saying if you've got those kinds of identifiers, whether it's a password, a user, alias, an IP address or something, that it will be covered if it falls under two different categories. One would be if it relates to a specific individual, or then whether it's created to maintain a preference profile. That may not cover every way that this information could potentially impact an individual at some time, but I think that would give business enough certainty to understand what's being covered and would cover the great bulk of the situations where people are concerned right now.
I think the definition, we're sort of in some ways putting the cart before the horse. The choice options that we identify really also matter, because when you put a blanket opt-in for third-party data usage, which is the Internet, we did a survey earlier this year that demonstrated that over 80% of all online advertising campaigns used behavioral targeting or techniques. So when you're talking about opt-in for third-party data usage, you're talking about the vast majority of the economic engine of the Internet. So it really matters what choice mechanism you give, because the stakes really get high. Now, in our self-regulatory system that we put out, we actually followed very closely the FTC's own definition, which was extremely broad and included, sort of all data used for behavioral advertising, online behavioral advertising. But because we had an opt-out requirement instead of an opt-in, it was something that our industry, at least, I can speak for us, we could live with that. We could live with a broader definition if we got the choice mechanism right. So I think they all kind of, this is a holistic bill, and the different provisions really have to work together. You've had great staff work to put this together, and we just need to be cognizant of that, and we stand ready to work through those issues with you.
do you have any additional questions?
I'll just make one other comment. We hear a little bit of debate about adopting a fully opt-in system, and we've heard some people say what it would significantly impact e-commerce in a negative way. How many of you feel that it would? An opt-in system would dramatically impact e-commerce? Okay. Great. So almost everybody up there, except I guess you, Mr. Merwinski, and
there's some ambiguity here.
Go ahead.
Okay.
Go ahead.
Yeah, I think that we've been struggling with this question for a long time, and I'm not speaking for the commission now. I'm speaking for staff. I think there's too much freight given to the question of the label of opt-in or opt-out. The concepts are not self-defining, and skilled marketers, and there are lots of them out there, can easily make either method of expressing choice either easy or difficult. We've both given what is called affirmative consent because we've clicked a button, and we've both, all of us have easily given in to either method. In our view, the question really doesn't boil down to this label. It's a legal label. It's not really a practical label. We believe that the goal ought to be to ensure that consumers are well informed and are given easy and clear tools with which to exercise choice. Clarity and ease of use ought to be the key metrics not easily manipulable legal terms like opt-in and opt-out.
Okay.
And that's where we think the real problem is.
Thank you. Thank you. You agree?
I have nothing to add to that.
Okay.
I think he's entirely correct.
We should have asked him a question earlier.
I'm fine.
Well, the chair, that concludes our questioning, and I again want to reiterate to the witnesses how appreciative we are for you taking your time to come and share with us your expertise and your insights into this process, into both the draft, Mr. Boucher's draft bill, and to H.R. 5777. And the chair wants to assure everyone who's present, and including our witnesses, that there will be ample opportunity for more input before we mark up this bill. I am cognizant of the fact that this bill was introduced 4 days ago, and we're having a hearing. But I'm also determined that we need to move forward. I'm not sure. There won't be there'll be a lot of deliberation, but won't be unnecessary delay in terms of getting this bill to the full committee and hopefully to the floor. And we want to work with some. I want to give you assurances that your time is just not being wasted here. It's really your investment in this process will result in a better bill, but it will be a bill that hopefully will become law. And I want to thank you so very much for being here this afternoon. And with that said, the subcommittee is now adjourned.
Next, another machine power punches assembly holes